So, yeah, that's what I do. I think 25 would be. Oops.
Hello? 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 Can you hear me?
Sherry, this is Phyllis.
Hi, how are you?
I'm good. I'm logged in.
Okay, good. We're
All right, I'm going to mute
some
myself.
technical difficulties here. Not sure everybody can hear me.
Yeah, I can hear you, so I'm going to mute myself.
Okay, good.
Yeah, I just wanted to let you know I was here.
Okay, thanks.
Okay, thank you.
Everybody can hear okay?
Yeah, there's just storms here in the area. They're starting to come up, so.
Oh, goodness. Okay, no worries.
If I get disconnected, then that's what's going on.
No problem.
All right, thank you.
Okay, yeah, it kept wanting to mute me, which I'm not sure why. That's not very nice. But I think we should be okay. We should be good to go. So, anyone have any questions? Or, well, you should have taken the Module 4 unit exams, right? Any questions on that? I don't think so, Parker. That wouldn't, white males are not considered to be a protected class. It's just for protected classes. Good question, though. It could be considered reverse discrimination, although reverse discrimination is kind of hard to prove. But it potentially could be, but usually that's a pretty sticky one to try to prove. So did anyone take Module 4 tests yet? How did it go? Not yet? Okay, do the flashcard reviews. That would be good. Okay, so we're still waiting. It's okay. We still have some time. It's good. Done. All right. And again, keep in mind that you're shooting for that 80% mark. Right? That's your goal. Now, for tonight, I've noticed a little bit of discrepancy, and let's touch base about this. So hopefully you can all see my screen at this point. Tonight we are May 7th, so we are covering Unit 5. Now, it says pages 1 through 47. However, if you look at our next class, which would be on the 11th, it says pages 35 to 71. So, my plan tonight is to go through about page 34 so that we can pick back up according to the schedule at the next session on page 35. Is that okay with everyone? Sorry about that. I just noticed that was a discrepancy, and as I mentioned before, there were a couple of additional pages added to Module 5 that don't exist. So we have a little wiggle room, which is good. We can see what we want to do with that, and I had extended a couple of the sessions, so if you haven't gotten the email, please let me know. But I figured that was fair, and that way maybe it'll give you a little bit of a breather and let everybody catch up. Okay? So tonight we're going to go Unit 5, page 1 to about 34. And then when we get together on Monday, we'll go Unit 5, pages 35 to 71. Okay? Any questions before we jump right in? Whoops, let me get back to the top here. Not that one, this one. All right. So, does anyone have experience with labor relations or unions? Any experience with labor relations or unions? No? They may unionize, okay, back in the 80s. My first experience with unions was at Anheuser-Busch. Oh, Jane, please feel free to share your experience as we go through this module. 9 unions, wow. My first experience with unions was through Anheuser-Busch, and that is Teamsters. The hourly employees were unionized, so I got experience with the collective bargaining agreement, with what that meant as far as how the union operated and how the employer operated, and what things could and could not be done by management employees. Things that they called, that's union work, and union employees should be doing that. Things like changing my light bulbs in my office. Not something that I could do. I had to call a union employee and get them to do that because that was deemed union work. So very interesting experience. And again, very strong union. And unions typically result from some poor employee relations practices or poor employee relations matters, that the employees feel that they would be better served in a unified capacity versus an individual capacity. So, on page 1 of Module 5, let's start at the beginning. Page 1 of Module 5, employee relations is the working relationship between the employer and the employees, which encompasses the rights of each party, how decisions are made, and how problems are resolved. In union companies, this function is also called labor relations or industrial relations. Major step towards establishing industrial peace occurred when federal laws endorsed collective bargaining as the primary method for resolving disagreements. So collective bargaining is the process that we use to resolve disagreements. Your agreement that is a result of this is called a collective bargaining agreement. Now, and I'm still on page 1. We haven't gotten too far yet. The National Labor Relations Act of 1935, also called the Wagner Act, established the legal right for labor unions to exist. Before that time, the existence of unions was uncertain and threatened. Labor leaders lobbied for the passage of several state and federal laws only to see them nullified or used against unions after they were passed. During the 1800s, major tactics were used against unions. We have to keep in mind, employers can exist without unions, but unions can't exist without the employers. Now, here are some anti-union weapons that were employed on page 2. Conspiracy. Used against labor unions in the early 1800s, judges found that unions caused or planned to cause injustice to other people or society. The court injunctions. Injunction is a court order that directs a person or persons to refrain from pursuing a course of action. So, most cases, this injunction is used to protect property rights, which includes the rights of workers to hire, to sell goods, to run the business in a profitable manner. Was there a question? No? Okay. Yellow dog contracts, and this is, again, something you're going to want to be familiar with. Statement employees were required being the key, to sign in which they agreed not to join a union. That was called a yellow dog contract. And antitrust statutes. Union leaders thought the Sherman Antitrust Act of 1890 would protect them from powerful hostile corporations. The law made no specific references to labor unions, and unionists found that it was very limited in a variety of vital union activities. So unions were interpreted by the courts as illegal combinations and restraining interstate commerce when they attempted to strike. So that's what the antitrust statutes were all about. Now on page 6, talks about the Federal Anti-Injunction Act. This encouraged the formation of labor unions by neutralizing the differential power between employees and employers, limited power of the courts to intervene in labor disputes by limiting the use of court injunctions. And the act was intended to encourage collective bargaining, but workers still lacked the protection they needed to effectively engage in collective bargaining activities. So, the Norris-LaGuardia Act pretty much said courts are not allowed to decide the legality of a strike. So they pretty much took some power away from the courts. So the courts couldn't decide the legality of an actual strike. And there were a bunch of other restrictions, such as not allowed to restrict labor unions from giving aid, such as strike relief funds, and so forth. So pretty much what was happening is the courts were intervening in the situations, and it was making for less than fruitful union labor activities. Now, there are also some threats to collective bargaining. You can read through these on page 7. Norris-LaGuardia Act restricted court interference in labor disputes, but it did not restrict interference from other parties, such as the employer. The act was intended to encourage collective bargaining, but the workers still lacked the protection they needed to, as I mentioned earlier, effectively engage in collective bargaining. There were many things, such as those listed here. Industrial espionage. Employers hired agents from their own organizations or from professional detective agencies to spy on union members, and then the spies typically tried to destroy others within the union by advocating violence. Seems like something inherently wrong with that. Attacks on union leaders. Many union leaders were killed or beaten by hitmen that were hired by the employer to discourage the union activity. That's concerning. Strike breaking. Employers tried to destroy the union by making strikes ineffective. Some strikes were broken when employers refused to negotiate with the union and encourage workers to return to work. So I know at Anheuser, when we were going through the collective bargaining process, we, prior to that, planned in the event of contingency planning, in the event that the workers do decide to strike, what do we do as an organization to maintain our business continuity, to maintain our business entity, to make sure that we don't go out of business during the time of the strike? If that happens, then, everybody's got a problem because everybody's out of a job. So that's something that you have to keep in mind as well, is what does this particular piece of our collective bargaining agreement matter? Kind of the so what. And then company unions, less violent method of controlling union activities. So just keep in mind that there were continued threats. It wasn't necessarily an easy road to unionization by the union, and there were plenty of threats to the collective bargaining process itself. Now let's go through some of these acts. On page 8, the National Labor Relations Act. So, employees shall have certain rights. Excuse me. Take a mint here. Employees shall have certain rights. Right to self-organize, to form, join, or assist labor organizations, bargain collectively through representatives of their own choosing, engage in concerted activities for the purpose of collective bargaining. Now, they also talk about ULPs, unfair labor practices. You can read through the 5 ULPs that are listed there on page 8, such as unlawful for an employer to dominate or interfere with the formation or administration of a labor union. A lot of these, if you think about it, we look at making sure that there is a separation between the union person and the organization as far as the administration of the labor union. And we'll talk about the NLRB, National Labor Relations Board, which was created by the NLRA. So National Labor Relations Act, which is what we're talking about here, also called the Wagner Act, actually created the NLRB. So the way I like to think of it is NLRA created NLRB. The act created the board. Oops, sorry. On page 9, we talk about Taft-Hartley, or Labor Management Relations Act. The NLRA, National Labor Relations Act, was amended in 1947 by Labor Management Relations Act, popularly called the Taft-Hartley. Under the provisions of this act, collective bargaining was retained as the basic direction of national policy, but restrictions were imposed, especially on unions. Taft-Hartley amendments concern ULPs by the union, the rights of employees as individuals, the rights of employers, and national emergency strikes. For example, unions are not allowed to restrain or coerce employees in the exercise of their collective bargaining rights. Does anybody know what it means to invoke your Weingarten rights? And I did not say wine garden, Weingarten. Anybody heard of that before? What does that mean to invoke your Weingarten rights? I actually had somebody ask me, Weingarten? And I'm like, no. Not for Weingarten, not collective bargaining. It is a right of an individual union member, or the individual in a right to work state does not have to be a union member, as those who are in right to work states are afforded the same protection as union members. However, if they're not dues paying, then they don't get to participate in things such as elections. So, and I don't want to go too far down that path, that's in a right to work state. But what is invoking your Weingarten? Weingarten rights. Anybody got an idea? Yes. It means you are asking for your right to representation if you feel, it's fine, Parker, if you feel like there may be disciplinary or some sort of impactful decision excuse me, that could be made regarding you or your employment within a particular meeting, then you can invoke your Weingarten rights. And that means you want a union representative or a union steward there with you during that meeting. So pretty much depending on how it's going or how it's evolving, or even before you get into the meeting, you can invoke your Weingarten rights, meaning you have to have you are requesting, you don't have to, but you're requesting to have a representative for you. That is part of the rights of employees as individuals within the organization to be able to invoke their Weingarten rights in a labor relations situation. Now, Landrum Griffin, page 10. And again, you can read through the details of this information. Labor Management Reporting and Disclosure Act. That's a mouthful. This act regulates the internal conduct of labor unions. So not only are we making sure we have a framework for guidance for the employer, but also for the unions. That makes sense, right? It's fair. What's fair is fair. There are 5 major areas: Bill of Rights for union members, reports to the Secretary of Labor, trusteeship, conduct of elections, and financial safeguards. So the LMRDA, Labor Management Reporting and Disclosure Act, regulates the internal conduct of unions and union activities specifically around these particular areas. Okay. On page 15, we're going to talk about union representation of employees. Now, I will tell you, when I took the SPHR, I really thought that the union piece, the labor relations piece, was one of the harder pieces, only because I really didn't have experience with labor relations prior to taking the test. But I still did fine. So, you may just have to study the area a little bit more if it's something you're not familiar with. Make sure that you give it a good faith effort in studying. Again, it is possible because I didn't have labor relations experience and I passed the test the first time. But it took an extra initiative for me on the areas, like I wasn't as familiar with compensation and I wasn't as familiar with unionization, labor relations. So you may have to spend a little bit more time in those areas studying if you're not as familiar from an experience level. Okay? So union organizations, page 15. We have local, national, federation. We'll get into federation a little bit on some upcoming slides. Local generally represent a group of employees working in one area for a particular employer. Local unions have the most direct contact with union members. Members rely on their local union for social interaction, economic support, political power. Local unions can vary greatly in size and power, from 10 members to as large as about 40,000. National or international? Collections of local unions, usually in the same industry. Each of the 173 national unions has its own constitution, which establishes the rules and conditions for chartering local unions. So you can kind of think of this as kind of rolling up, local to national to federation. Now the AFL-CIO is a federation, large and powerful federation, on page 17. 57 national unions plus numerous independent local and regional unions belong to this federation. AFL-CIO represents approximately 12.2 million workers. Probably has changed. It's probably a dated figure. Chief governing body of the AFL-CIO is the Executive Council and representatives from national unions who meet in a national convention every 4 years. The group meets to set policies between conventions, has a large staff to provide information, advice, research, public relations for national and local unions. So as I mentioned, it kind of rolls up. This is the top of the food chain, so to speak. A federation, which is this one is the AFL-CIO. Now, on page 17, you can see in 2005, 7 national unions formed a new coalition called Change to Win. They had dissatisfaction with the AFL-CIO, which stemmed from the AFL-CIO's extensive involvement in political campaigns and inadequate efforts to recruit new members. So, unions heavily involved in political campaigns? Possibly. And that was one of the reasons that Change to Win left the AFL-CIO. Since these were some of the largest members of the AFL-CIO, their disaffiliation significantly reduced the numbers as far as membership and their budget by about 1/3. So that's pretty substantive. If they're reducing their membership numbers and their budgets by about 1/3. It's unclear whether the Change to Win will act as a competing federation, challenging the dominance of the AFL-CIO and its affiliates, or merely have just another federation, Change to Win, another federation of unions versus being a direct competitor. New coalition, 4 unions declared its intention to focus on recruiting new members at the local, national, and international levels, especially employees working for large multinational companies. So there was some unrest that went on here. Page 18. We talked a little bit about the NLRB, National Labor Relations Board. Can you tell me who created or what created the NLRB? What's another name? Yes, the NLRA. Good. NLRA created the NLRB. Right. This was established by Congress through the Wagner Act. Purpose, again, of the NLRB, protect the rights of employees, employers, unions, and the general public. Performs major functions such as conducting representation elections and resolving unfair labor practices, ULPs. Interestingly, I found out today that the university had implemented a new CPO, which is Certified Peer Observer process. So pretty much you went through and you got certified to be a peer observer, and then you would go and observe the individuals and provide them with feedback, kind of like a performance assessment. Well, and I don't know what the rationale is, but I do know that apparently the union filed a case or filed a grievance with the NLRB because they didn't want this to continue to happen. So I'm not quite sure where it stands, and honestly I was kind of surprised being a faculty member, but I'm not at this location, so I'm not covered by the bargaining unit. But that actually did just happen recently, where there were employees who didn't agree with this new process implemented by management. So what did they do? They filed a grievance, and now that process is kind of on hold. Yeah. So organizing a union, and you can read through a lot of this information, but make sure you know the procedure for organizing, and then you know the procedure for decertification. So first step, 30% of workers to sign the authorization cards calling for the union to represent them. 30%. Honestly, that kind of seems low, but that's the rule of thumb. That's what they're going to be looking for, is the 30%. After they've expressed the interest, they can petition the NLRB for a representation election. The NLRB investigates to make sure and pretty much verify the information, verify that the people really were employees of the organization or would be part of the potential bargaining unit. And then company must exceed a certain dollar volume of the business, or the NLRB will not respond to the petition. So the company has to be so big in order for there to be a response to the inquiry about unionization. Now, what are the steps or what are your thoughts for decertification of a union? Anyone? That's a great question. Why do you think the workers would want to be non-union? My experience has been that decertification is pretty rare. Okay, follow the same process as organizing. Yeah, so that's a good question, Parker, philosophically. Why would they ever want to be non-union? Maybe they just stop, fees, possibly. Maybe they just stop participating in the union paying dues. And what I saw at Anheuser-Busch was that it was very restrictive to, once you joined the union, it was very restrictive to get out. So, for example, if you joined and you were a dues paying member, you had a certain window that was a few days before and a few days after your actual joining date that you could cancel your union membership. If not, it remained in effect for another year. That's just the way things were set up. That was just the process that was set up. So we definitely have to keep in mind what those particular types of things are, if there are specifications by the union contract. And, it certainly could be expensive to be a member. Absolutely. Okay, so union disputes between members and officials. If someone's not real happy with what's going on with regard to their representation in their workplace, then, that could certainly be an impetus. Now, here are some things that you're going to want to be familiar with. I'm not going to go through each of these in detail, but, on page 24, after the union has won the election and negotiated the agreement, faces the problem of member apathy. Many members do not want to continue supporting union activities or paying dues. Now, union dues are something that the organization is going to need in order to be a sustainable entity. Unions have designed several arrangements for continuing membership, which they're listed here. Closed shop requires that only union members be hired. Applicants for employment must already belong to the union. The Taft-Hartley outlaws a closed shop, except for hiring halls in the construction industry. They exist anyway in such industries as longshore workers. So, closed shop might be kind of a tough one. Union shop requires anyone hired join the union within a prescribed period of time. Again, no, not something you want to be doing. Agency shop recognizes the union as a bargaining unit for union and non-union employees and requires everyone to pay union dues regardless of whether they're members or not. They're called agency fees. So that is the agency shop. And again, you can read through those, what it means to the union as far as security, what it means to the union as far as making sure that they're a viable, sustainable, ongoing entity. So let's talk a little bit about employer ULPs. So ULPs are unfair labor practices on page 27. The NLRB handles about 25,000 cases per year. As I mentioned earlier, I know the union at St. Leo has filed a grievance. So pretty much they're saying, wait a minute, there's something fishy going on here. I think we need to have a neutral third party come in and take a look to find out what this really means. Only 1/3 of the complaints actually have merit or are found to have merit, not my decision to make. Of these cases, 90% are settled. Many charges are dropped after the contract has been successfully negotiated. Other cases may be dismissed by the NLRB because they are trivial or because the NLRB just doesn't have time. It's kind of sad, though. NLRB faces constant challenge to improve the efficiency, since the full procedure from charge to complaint to hearing by a law judge really does require about a full year. So think about that. Think about being embroiled in somebody who took a bird to school, or somebody who did something such as, I don't know, just something that's off the wall that you wouldn't think of. And why would they want to file a complaint like that? I'm still kind of perplexed why they would make a charge of a teacher getting a certified observation. The only thing I can really think of is that it differentiates people in the workplace that doesn't make sense to union, because union wants everyone to be the same. And that's not necessarily the case within our workforce. Not everyone is the same, but union really wants it to be driven by seniority versus anything else. So, in the ULP, and now I'm on page 27, filing the ULP, a ULP is any action by union or management that is prohibited by law or NLRB ruling. Every case originates in one of the regional offices. A charge or petition is filed by the individual or organization. The ULP charges can be submitted by person or by email. And here's a date for you. Yes, Fonda, you're right. The union does have to survive. It, to me, just kind of seems crazy about some of the things that people may file a ULP about. They must file within 6 months after the alleged practice was committed. Now, what are some examples? Can you think of some examples of ULPs? What are some examples? Has anyone had an experience with the ULP? To file? Is there anything you can share that, is it because some I saw were things like management doing bargaining unit work, something along those lines? Oh, a perception? Okay. Okay. So again, things that are perceived to be unfair practices. Okay, so changes, maybe unilateral changes is what I had typically heard, is unilateral changes that could substantiate a ULP. Promoting men over women. Okay. Sure. And that would have to be researched and obviously proven and substantiated, and usually they do take time. They may take a long time. Now, what do you think would be considered unlawful support of a labor organization? On page 31. Paying members' dues. Of course, the organization would want to take those funds or fees out of the union members' paychecks, and then they'd pay the union those dues, absolutely. But to pay them directly without pulling the money out of their checks could be considered unlawful support. Yeah, financial assistance. Labor management participation on teams is another one. Employers must use caution in creating quality improvement committees that include members of management and labor. Quality movement has permitted many organizations to implement employee participation teams to improve productivity and so forth. The effectiveness and importance of these committees is indicated by their continued use. The NLRB has ruled, however, that these programs may be considered employer-dominated. So, just have to be careful. Again, it's really about perception. We have to be very careful about the perception. So, let's talk a little bit. Okay, yeah, I want to talk a little bit about union, unfair labor practices, strikes, boycotts, and so forth. And this is actually the last section I want to cover for the evening, since we discovered that there was a lot of overlap between tonight and next week. And as we agreed, we're going to stop after this section, which will take us to about page 37. Is that good? Actually, you know what? Let's not go into this section, because this section gets into good faith bargaining and strikes and whatnot, and I don't want to cut us off in the middle of this. So let's stop here before we get into union ULPs, strikes, and boycotts. I definitely do want to take another look at our calendar. So tonight we went through about page 35 is where union ULPs, strikes, and boycotts start. So we were right on target. So we covered about page 1 to 34 in Unit 5. And next section we will cover is 35 to 71, and then so forth. And you should have received the updated schedule where we will start having some extended sessions so that we can have the holiday off. But it seems like something wacky happened with our page numbering here when administration was filling it out, but it's okay. I think we're straight. So I will end it here for the evening. Is there any question that you have? Any questions that you have, or are we good to go? We're good? Okay. Well, thank you guys. Thank you everyone. And I will see you all at our next session on Monday. Have a great weekend.
Oh, and thanks, Sherry. You too. The call-in actually worked great for me down here, so I wanted to appreciate it. Thank you very much for that.
Okay, so you're good.
Mm-hmm.
All right, awesome. Well, if you have any questions or anything, just let me know.
Okay, will do. Thanks, Sherry.
Okay, sure.
Bye-bye.
Bye-bye.